I think what they would say, and I'm sure we'll hear it, is that, if we're talking swords and shields here, it sounds like your client is the one using his Fifth Amendment right as a sword, not a shield, right? By selectively trying to put into the record mental mitigators, but then not cooperating with, the state's effort to assess those mitigators, the strength of those mitigators.
And I'm saying that they had all the information they needed to assess them. And if you look at what the state asked for as its remedy for Abdul refusing to go over again with this doctor his actions, they said, our remedy, which would fully support what we need, is to have this doctor tell the jury what Abdul told the police.
All right, let's break this down. What you're about to see is a justice pressing the defense hard on whether the Fifth Amendment is being used fairly in this penalty phase. The question is simple. Can you put mental mitigators into a record but refuse to answer certain questions about the crime itself? Let's take a listen.
So they're trying to use this rule as an evidentiary sword, I would say. And he's had and consider that they had a doctor, Dr. Tressler, who Abdul had already told the same thing he told the police, and the state attorney says that on the record. So that's all comes out when the state originally is moving to after the suppression order to allow Dr. Tressler to be able to testify to everything that was in the confession. So there's no reason why they didn't have an ability to put all that in front of the jury if that's what they were trying to do.
Excuse me, didn't this court reject your argument back in 2000 in Curse versus State and during direct appeal in this case?
I think those were different.
Curse pretty much said, and finding that Rule 3.202 serves as an important purpose, basically a leveling playing field for the state and for the defendant.
Okay, but my argument is that the playing field was level because this doctor had all of the information that the defense had turned over. All of the examination, mental health reports, tests, and evaluations to the state, and Dr. Demery had that. And if you look at in this record, there is Dr. Demery's notes and a deposition that were taken all around the time when this is being argued. At R4231, he's discussing all of the interview that he had.
What was the specific question that was asked that he refused to, that your client refused to answer? What was the point?
So if you look at, especially in Dr. Demery's notes, he in the second interview, Abdul goes into everything that happened up until about midnight. And so, I mean, that included the drinking, the going to the 7-Eleven. He's told this doctor all of that. And the only thing he's not going to do is go over his specific actions that occurred during the murder after midnight. The doctor never asked him about anything after that. So he just said, okay, tell us what happened after, and he said, I'm not going to answer that. So the doctor already had the answers to these. He had the interviews, and they had Dr. Tressler. So they're not using this as a discovery tool. And the sanction is not really requested by the state. The state is asking for to allow the confession to come in through their doctor.
Can you describe exactly what you're alleging was not presented precisely? What was the state of mind mitigator that was prohibited?
Okay. Well, there was very long proffers because what the defense was precluded from putting on was very broad, and that was anything that went to what his state of mind would have been around the time that this all occurred. And so the defense experts were very limited. They were only allowed to talk about their diagnoses, but not how that would affect a person.
Well, I guess I'm just having a hard time understanding how that's not. I mean, what you're saying is that's all stuff that happened after midnight, but yet he refused to talk to the state's mental health expert about all of the stuff that happened after midnight. So I mean, I think I can see why the trial judge was at least within the discretion.
This is where the court signals real skepticism. The judge is essentially saying that if the defense wants to talk about Abdul's state of mind during the murder, but refuses to discuss murder details with the state expert, then the trial judge's sanctions may have been justified. That's the balancing act the court is wrestling with.
Of saying, well, no, if that's what the mitigators are trying to put on is about his state of mind as he's committing these murders, then he's not answering the state's expert. How is the state going to rebut that?
Okay, if you look at what the testimony was from the defense's experts, they are talking about his life and their testing and their evaluations of his family and the neuropsych. And even Dr. Demery says my discussion of the neuropsych has nothing to do with the events of the crime. So they're talking about, and all three of them would have said in their proffer that he was suffering from extreme emotional disturbance at the time, and his capacity to appreciate the criminality of his conduct or conform to the requirements of the law was substantially impaired. And they get that not from the events of the crime, because they didn't ask him about that. They get that from the testing and the diagnosis of him having a severe nonverbal learning disability, plus the family situation with the mother. There's a lot of things that go into it that is discussed in detail, but they're not allowed to give even his age. They're not even allowed to say how his age and the mental factors that would go into a 19-year-old, how that would impact his decision-making at the time. And when Dr. Demery testifies, he refutes everything that they are relying on, but they are not allowed to say that what they're relying on, how that would affect a person in a stressful situation, which is, the situation that was going on with the girlfriends and his age and the false pregnancy and all that. So everything that they had were relying on to draw their conclusions was everything that Dr. Demery also had, and he was refuting exactly what their diagnoses were. And he was saying, he didn't have a problem with his family. He didn't have a learning disability. So to say that the defense couldn't put on what would be drawn from those conclusions, because that would impact his state of mind, is just completely overbroad. And it's nothing to do with what Rule 3.202 envisions, because this rule envisions ordering the state's expert to review all the mental health test reports, evaluations. Well, he was able to do that. He already had done that before the state even moved for sanctions. And then the second thing is prohibiting defense mental experts from testifying concerning the test evaluations and examinations. Well, they were allowed to do that. They just weren't allowed to say what that meant as to a person in this situation. So the jury is not hearing the most important mitigation, the conclusions that experts would draw as to all of these factors that was going into making this person who he was.
But isn't it, I mean, it seems like there's two aspects to it.
Now, this is the key distinction. The justice is separating general mitigation, things like background, mental health, and testing, from the incident-specific mitigation tied directly to the night of the murder. The court is basically saying, even if the first category is allowed, the second category still requires cooperation, and that is where the conflict lies.
I mean, one is just sort of the general mitigation of someone who's had these experiences and has these conditions and everything, and how that might affect sort of the overall culpability of the person, right? And then there's the second part is, given all those things, how did it affect this specific incident? And you can, you could treat the first thing as being established and mitigating, and then there would still need to be proof on the second part as to this particular thing and how it affected the events that played out and everything. And it seems like the trial judge was trying to tailor a remedy that kind of leveled the playing field as to the second aspect and still let the first aspect be aired. And so what's wrong with that?
The trial judge really never put the state to the task of saying how they were somehow prejudiced by Abdul not repeating his suppressed confession to this doctor. And like I said, as the defense was saying at the time, these experts whose testimony was known, and Dr. Demery was able to sit in and listen to them. So if they had gone on and said what was going to be proffered, which there is volumes of it here, there's no reason why that couldn't be refuted by a state expert who refuted all of the predicate assumptions that the defense was relying on, these defense experts. I mean, he said to the jury, this boy doesn't have a learning disability. And the defense three experts all are relying on his cognitive problems and him being, at least 3 years behind in maturity and cognitive functioning. So if Dr. Demery testifies, which he did, that he thought he was actually advanced in his maturity and functioning because he was working 3 jobs at the time. So there's no reason why he couldn't have gone on and also refuted what they were drawing from the stressful situation. All of that was part of what he was interviewed Abdul about.
Interesting moment here. The court is really trying to balance the Fifth Amendment protections with fairness in the penalty phase. Let me know your thoughts below, and we'll break down another one soon.